And tell me if we want to go, when we want to go.
Okay.
Take a slide. Good morning and welcome to the New York State Gaming Commission staff hearing regarding conflicts in sports events upon which wagering occurs. Before we commence, I want to note that participants have been scheduled in advance. Should anyone listening who is unregistered and unconfirmed have interested in providing input, they should promptly call 518-388-3407 to schedule a time. Again, that number is 518-388-3407. If anyone would like to provide written input, please email your material to our information mailbox at info@gaming.ny.gov. My name is Robert Williams, and I serve as Executive Director of the Commission. With me today from the Commission's Counsel Office is Edmund Burns. From the Division of Horse Racing and Parimutuel Wagering are Ronald Okram and John Gugas. From the Division of Gaming are Thomas Annapolis, James Gugas, and Scott McClear. And from Commission Central Administration are Steve Lowenstein and Brad Maoni. It is also my understanding that several Commission members will be participating or listening to these proceedings. The intention of this hearing is to receive public input on the topic of regulation of potential conflicts in sports events upon which wagering occurs, from which staff may craft proposals for rule alteration if we determine it is appropriate and necessary. As a point of background, Governor Kathy Hochul issued veto message number 49 late last year, disapproving legislation that would have prohibited the Commission from requiring the coupling of entries in thoroughbred horse races when a horse is trained or ridden by a spouse, parent, issue, or member of the household of another jockey in the race. In the veto, Governor Hochul directed the Commission to review the continued need for mandatory coupling and the circumstances under which such a requirement might be relaxed, and to seek input from industry stakeholders and the wagering public regarding this topic. In thoroughbred horse racing, Commission Rule 4025.10 currently requires coupling, the combining of related entries in a race into a single betting interest of entries in certain circumstances that might present a conflict of interest among competitors in the event. The policy behind the coupling rule appears to seek to mitigate concerns that closely related parties may not expend maximum effort in the underlying contest, with one party sacrificing to the interests of a related party. With the implementation of sports wagering, the same perceptions and concerns evident with horse racing coupling rules may be present in wagering on other sports events. Accordingly, this hearing also seeks input on the topic of potential conflicts in all sports events upon which wagering occurs, including conflicts that may not have been considered in the context of horse racing. For example, internal discussion amongst Commission staff also finds some concern with sporting competitors who have an ongoing but not formal personal relationship. I note that the existing Commission rules governing sports wagering fail to address these concerns, and we've been unable to find a matter formally addressed elsewhere in the United States. While the Commission staff posed several questions and issues to consider while crafting input on these topics, we are interested in all opinions and views. At this time, I'd like to ask if any of my fellow Commission employees would like to add any preliminary comments prior to commencement. Hearing none, before calling our first participant, I would like to read into the record a brief statement submitted by Senator Joseph Addabbo, the chairman of the Senate Racing, Gaming, and Wagering Committee. As chair of the Senate's Racing, Gaming, and Wagering Committee, I am extremely interested in hearing and evaluating the testimony given at the Gaming Commission's hearing on Monday, January 11th. After Governor Kathy Hochul vetoed my bill, Senate 6390, a bill that looks to end the mandatory coupling of entries in a race which married jockeys ride, I appreciate her suggestion that the Gaming Commission review the issue of mandatory coupling. I want to thank Governor Hochul and the Gaming Commission for presenting this hearing so we may listen to testimony from individuals with knowledge of this matter, assess the testimony, and work in tandem with the governor's administration and the Gaming Commission to fairly and equitably address any related issues pertaining to mandatory coupling. At this point, I'd like to call our first hearing participant, who is Bennett Liebman. Mr. Liebman is a government lawyer in residence at Albany Law School and an adjunct professor of law who is certainly well known to the commission. Among his long career in public service, Mr. Liebman served as a member of the New York State Racing and Wagering Board for more than a decade, including a term as its acting co-chair, and he concluded his government service in 2014 after 3 years as deputy secretary to the governor for gaming and racing. For a decade, he worked as the Albany Law School's Government Law Center coordinator of a program on racing and wagering law, and as the center's executive director. He has written hundreds of articles on horse racing, gambling, and New York State government. Mr. Liebman?
Thank you very much for that extremely nice and unnecessary introduction. When I learned that the Gaming Commission was going to explore holding a hearing into the topic of conflicts in sports events upon which wagering occurs, I thought this would be a great topic for a law review article. And I've got a great title, Family Ties, Divided Loyalties in Horse Racing and Other Sports. It is a good topic. I'm about 5,000 words into writing a law review article, but it has a problem. It's what I like to call the Sam Rayburn problem. You may remember Sam Rayburn. He was the longtime Speaker of the House of Representatives. He's famous for his quote, "Any jackass can kick down a barn, but it takes a good carpenter to build one." And that's what I see looking at horse racing's rules, dealing with divided loyalty based on familial, personal, and business ties. It's easy to knock them down. They're ambiguous. They're over-inclusive and under-inclusive. I can knock down the barn, but I can't build a good replacement barn. I can construct a good first act. I don't have a remotely decent second act. And as a longtime state official, I hate that attitude. It's not remotely helpful. It's saying, you stink, figure out how to fix it. Hopefully I have a few suggestions that might be maybe a tad helpful. Now, here's how we got to the specific problem of the requirement that married jockeys have to be coupled. It starts in 1969 when racing commissions across the country were forced to let female jockeys ride. You had an almost immediate problem because jockeys Mary Bacon and Johnny Bacon, who were riding at Finger Lakes, were married. The answer from the stewards in New York and across the country was simple. They can't race against each other. Stewards and racetracks everywhere ruled that they couldn't testify against each other or claim foul against each other. A suspension of one of the riders also required the suspension of the rider's spouse. They just couldn't ride against each other. The rules governing spousal jockeys likely forced the divorce of the Bacons in 1972. And that's where we stood in New York until 1985, when the Racing and Wagering Board placed all the divided loyalty jockey questions into one rule. The board promulgated Rule 4025.10F, which has remained unchanged since that date. Rather than banning jockeys with family ties from participating in races, it forced coupling of all horses where a jockey had a familial tie to other participants in the race. Coupling was required where a jockey is competing against a spouse, parent, issue, or member of a jockey's household. So the rule allowed spouses to ride against each other, and Coupling was not a huge deal in 1985 when a bettor was limited to wagering at an in-state racetrack. It seemed to resolve most of the divided loyalty jockey family issues. But times have changed. The ambiguities have emerged. Are cohabiting licensees members of the same household? When Angel Cordero in the early 80s provided a home for apprentice jockeys Harry Vega and Lauren Ayub, were they part of his household? States now regularly let spousal jockeys compete against each other. In 1998, the Massachusetts Racing Commission let spouses Harry Vega, the same Harry Vega who had lived with Angel Cordero, and Harry and his wife Amy Duras to compete against each other. Nobody batted an eye when Chantal Sutherland and Mike Smith, who were living together in California for several years, competed against each other. On the parent issue side, we even saw a race in California in 2015 where 54-year-old CeCe Lopez competing against his sons Eric and David without any coupling. And with betting allowed throughout the world, how are you protecting New York bettors when they can bet on Trevor McCarthy racing against Katie Davis in Maryland, but not when they're racing in New York? But at the same time, many of these same states that allow spousal jockeys to compete against each other have rules, including the ARCI model rules, that have a provision limiting or banning a jockey from racing against a horse trained by his or her spouse. How do you justify the distinction between spousal jockeys and spousal jockey versus spousal trainer? Moreover, why in New York and elsewhere is the family competition rule seemingly only limited to jockeys? For years, family-connected trainers have competed against each other without any need for coupling. We had the Martins, Hall of Fame father Frank, son Jose, and grandson Greg, all competing without any couplings. In the 80s in New York, we even had the Sedlock family, husband Woody, wife Sue, and kids Roy and Mike, all training horses without rules requiring couplings. Why have riders been treated more harshly than trainers? Our rules are all over the place. Any jackass can kick down our current rules. And now we have betting in New York on all sports, and we have the same divided loyalties in these sports. Look at tennis. You have families playing against each other, McEnroes, Williamses, Pliskovics, Murrays, players competing against each other who are coached by the same individual. You have people playing against your double partners in singles. Look at the 70s. With Billie Jean King playing against Rosie Casals, Martina Navratilova against Chris Evert, Pam Shriver, Tom Ocker playing Marty Reason, John Newcomb v. Tony Roach. You may remember that Chris Evert stopped being Martina Navratilova's doubles partner because there was a feeling that it might affect how she played against Martina in singles. You have people playing against players who are your teammates in major international competitions. Your players playing against spouses or partners in mixed doubles or other matches. Back in the 70s, you had ownership or control of tournaments by somebody like Donald Dell, who was the agent and lawyer for a large number of players. Conflicts were everywhere. And we have the same friends, families, and business divided loyalty issues in other sports. Look at the Friends. Michael Strahan in 2001 was gifted the season sack record by Brett Favre and the Green Bay Packers. That's now a bettable event. Just look at T.J. Watt tying that record this past Sunday. In baseball, we've seen purposely grooved pitches to friends, from John Drysdale to his longtime teammate Duke Snyder for a home run in '63, and Adam Wainwright grooving a pitch to Derek Jeter for a double to start off the 2014 All-Star game. We've had parent-child conflicts where Felipe Alou managed against his son Moises. And we've seen conflicts among the Schulas, Bowdens, Rivers, Sutters, Patinos, and Dunleavys. We've had the business divided loyalties issue. Look at the 50s Kansas City Athletics and the 1920s Boston Braves. They were operated as vassal states of the New York Yankees and the New York Giants, respectively. Sports owners have owned pieces of other franchises. Charles Bidwell, who owned the Chicago Cardinals, had helped George Halas financially and owned a part of the Bears. Clearly, there was all kinds of mixed ownership in the old NFL. So the sports we can now bet on have the same divided loyalty issues as horse racing, yet they don't ban these conflicts or even announce these conflicts. And while I'm a terrible carpenter who can barely hammer a nail, let alone build the barn, let me suggest several ways to approach this divided loyalty issue. One, who should regulate the divided loyalty issue? Should it be regulated by operators of the sport itself or by the organization which regulates the gambling on the sport? Should the conflict of interest issue simply be banned? For example, in the spousal jockey competitors issue, would you simply ban the spouses from ever competing against each other? That was number two. Three, do you regulate the conflict of interest by coupling the conflicted participants as a single entry, like we do with 4025.10? Four, do you allow the conflicted participants to compete against each other without any coupling, but notify the public of the potential conflict? Do you take no action on the conflict and simply let the conflicted competitors compete against each other, thereby instituting a laissez-faire, let the better beware policy for conflicts? Six, are the answers to these questions affected by whether the wagering is pari-mutuel, with the wagering involving the players betting against each other, or does the public policy change when the bets are banked and being placed against a mega gambling firm such as FanDuel or DraftKings? Seven, does the state have a greater obligation to act against a potential conflict of interest when it involves a sport like horse racing, boxing, or mixed martial arts, where the participants are subject to specific state regulation? And eight, rather than limiting entries for wagering, would it be preferable to follow the example of legalized sports wagering and restrict actual sports participants and their proxies from wagering? Similarly, should there be more formalized penalties for disclosing inside information on sporting events? I do have some very tentative suggestions here. In horse racing, we need uniform rules of the race to govern the actual conduct of horse racing throughout this country. We're now set to have uniform national drug and safety rules, but there's absolutely no reason not to have uniform rules on the race, which would govern the full conduct of the race and the eligibility of all the participants in the race. Why should Maryland's rule on this subject be different than New York's? Two, while disclosure of major conflicts may be necessary, it's nowhere near sufficient. Disclosure doesn't work well. Disclosure failed at the Breeders' Cup in November in the juvenile turf race. Few knew the betting status of the eventual winner, Modern Games. We've had ample experience in New York to know that late rider equipment and gelding changes have never been communicated well, even where nearly all the bettors were at the track or at an OTB branch. Getting an announcement at the track is like getting an announcement at a subway station. And in these days of mobile betting, these announcements are even less likely to reach the intended audience. Three, let's begin to put a cap on who can bet and how we convey insider information. I know that racing once seemed to feed on insider play. Everybody wants to think they've got the horse right here. But it's time to stop horse racing from further devolving into an insider's game. I would direct you to the rules of the British Horse Racing Authority on the limits on communications of insider information. Finally, we do need to look closer at the instances where horses that share the same owners and or trainers assist each other in the course of a race. I would add to this list of improper assistance those races where there's a close familial interest involved in the race. Again, I would direct you to the rules of the BHA on assisting another horse in a race. If we want to avoid even the perception of conflicted loyalties, we need to have stronger rules and greater enforcement here. I've talked enough. I know my limitations. I'm not raising a barn. I'm barely constructing a fence. I don't know what the ultimate answers here are. I do know, however, that this is the most important subject and it merits everyone's best efforts and work here. You, staff of the Gaming Commission and its members, you can begin to construct a new barn and you can write a better ending, the proper ending for the second act here. Thank you for letting me speak.
Ben, thank you very much for your participation here. Does anyone have any questions for Mr. Liebman?
Rob, it's Ed Burns. I'll jump in with a question.
Please.
Ben, thank you for your input, which is very helpful to the commission. If, to take up your metaphor, the Gaming Commission were to construct a new beautiful barn, would we be the only building standing in the world in this space? You know, would we be outliers in trying to undertake that type of project of thinking through all of these interstices compared to the regulatory regimes in other jurisdictions around the world?
The answer is that hopefully it would begin to be part of the uniform national rules on the actual running of races that I pray for in the racing industry. So yeah, you'd initially be by yourself, but hopefully the other commissions, other groups would see the path.
Thank you. And can you shed some light on the historical carve-out that we've had in this particular rule for stakes races and why it was relaxed in those circumstances?
This is what was come to be believed as gospel in the racing industry is that racing handle is largely to a certain extent determined, and at least certainly in a particular race, by the number of betting interests in the race. So that the greater the number of interests in the race, the greater the betting handle. It's very important. In a lot of races now, and especially in thoroughbred racing, certain dominant trainers, are there. How many pletchers will you see in a major stake race? If you reduce the number, if you couple all the pletchers, all the Bafferts, suddenly you have a race that's far less interesting to bet. You may even have in very major races, a race that's unbettable because you're not going to be able to get any wagering on exotics when you're dealing with. Again, we started, like say, the 90s when Wayne Lucas was the dominant trainer. You just don't have the entries because of this. So the idea was that in order to make sure there was a considerable betting on these races, we relaxed the rule. Otherwise, we have enough problems in racing finding full fields for major stake races.
Would that be an issue with respect to jockeys with familial relationships as opposed to trainers?
Offhand, I don't think so.
Right. And I'm also curious about the history of harness racing, which I know you have expertise in as well. Did these types of issues historically come up in the harness racing context as well?
Not in the same way, but if you look at harness racing, I mean, which has always, there's again, harness racing. If you look, I think what running of the Hambletonian is, where you actually saw the issue of a horse, of a driver letting another horse, a part of what would have been a mutual combination in the past, get through. Yet you have it, but far less. What you had in harness racing was so many dominant families. You had so many Filions in the 60s and 70s who were driving. You look at all the relatives of Stanley Dancer from the 50s to the 70s, where you had, brother, uncle, son. There were so many dancers. They were all not coupled. But we had a number of Houghtons for years racing, because you've had in harness racing a lot of families that were extremely dominant in the sport. But harness racing has I think been less resistant to coupling.
Thank you very much.
Anyone else have any questions for Mr. Liebman? Ben, we appreciate your participation in this, and we appreciate the time and effort you've taken in actually thinking about this issue. I know you and I have had a number of conversations.
If I ever finish this article, I will forward it to everybody. I'm not sure, however, that I will come up to any better conclusions than I already have. Just more examples of conflicts.
Again, I appreciate your efforts.
Okay, thank you. Thank you all.
Our next scheduled participant is the Honorable Carrie Werner, who represents the 113th Assembly District. Assemblywoman Werner is the chair of the Subcommittee on Agricultural Production and Technology and is a member of the Assembly Racing and Wagering Committee. Most importantly, for the purposes of today's topic, Assemblywoman Werner was the sponsor of legislation that sought to eliminate the Commission's interested party coupling rule. Assemblywoman?
Thank you, Rob, and thank you to the Commission for inviting me to speak with you today on the pressing issue of integrity in sports, and specifically of integrity in sports wagering. As the representative of the 113th Assembly District, a district that includes the historic Saratoga Racecourse, I am particularly focused on promoting and ensuring the integrity of the iconic and much beloved sport of horse racing. While we convene today to talk about the overarching and amplifying national and international threat of corruption in sports and sports wagering, involving numerous sports such as soccer, basketball, football, tennis, and horse racing, today I am here to speak specifically on one small aspect of the Commission's fight for integrity in New York's horse racing industry: the history, application, and consequences of the rule mandating coupled entries for married jockeys. As you know, and as Mr. Liebman has described, coupled entries represents two or more entries considered to be a single betting entry. Historically, why and when does coupling occur? For the non-racing participant in this hearing, I would say that we could look at one of the horse racing blogs description, which says the idea is if a trainer or owner is entering more than one horse in a race, he or she knows which one of the two horses is better, and could exploit that fact by using the other horse tactically to set up the race for the better horse. The purpose of coupling the horses into one betting entry is to protect those betting on the other horse, so even if the other horse isn't given his best chance of winning and the better horse does in fact win, the person placing the bet on the other horse is protected. The Commission's current regulations on coupling reach significantly beyond these traditional concerns by establishing 4 distinct mandatory coupling scenarios. 1, with respect to entries with common ownership. 2, with respect to 3 or more horses trained by the same person. 3, with respect to all horses trained or ridden by a spouse, parent, issue, or members of a jockey household. And 4, any time the Commission steward finds it necessary in the public interest. Although mandatory coupling automatically applies to all horses involving married jockeys or a jockey married to a trainer, entries coupled by reason of common ownership or training do not. In fact, in 2015, the Commission substantially relaxed the conditions under which entries with common ownership or training must be coupled. Specifically, the Commission lowered the threshold for mandatory coupling in stakes races from 1 million to 50,000. According to the notice of proposed rulemaking published in the State Register, the change was made to improve wagering opportunities in thoroughbred parimutuel racing. Additionally, the notice indicated that, quote, the proposal is consistent with recent amendments of a similar nature in other major racing jurisdictions, such as Kentucky and Texas. The racing stewards can closely monitor each race and have the authority to place any horse in a finishing position that is appropriate if collusion is observed, and the rule proposal requires further that bettors be informed by the racetrack of any common ownership or trainer among horses in the same race. In addition, the Commission steward has the authority to order that horses be coupled if necessary in the public interest pursuant to regulation. Similarly, although there is a blanket mandate to couple spousal entries, trainers not married to a jockey have carte blanche to run 2 horses in any race, completely unencumbered by the strictures of mandatory coupling. So why do married jockeys and trainers not engender the same level of professional respect as unmarried jockeys and trainers, even though the regulations confer flexibility on the Commission steward to make a case-by-case determination for coupling whenever such steward finds it necessary in the public interest? The regulations distinctly exempt siblings of a jockey from mandatory coupling. In fact, there are numerous historical instances of siblings competing against one another at the highest level of sport. Examples include, of course, Jose and Arad Ortiz of Saratoga horse racing fame, Eli and Peyton Manning, the well-known NFL quarterbacks whose opposing team clashed 3 times, and of course, Venus and Serena Williams, the tennis sisters who shared a household for many years and ultimately met in 8 Grand Slam finals. Why then do siblings confer such professional respect, whereas spouses do not? As anyone can plainly see, the regulations establish a double standard. Why does the Commission automatically presume match-fixing tendency in spouses? Nothing in the history of the origins of New York's regulation, nor the experience of other states, suggests a basis for that fear. New York's mandatory coupled entries regulation came into effect over 35 years ago in 1985. The New York State Racing and Wagering Board added the rule with little explanation. The notice of rulemaking from August 15, 1984, stated that the rules are needed to, quote, ensure integrity and the appearance thereof in thoroughbred races upon which parimutuel betting is conducted. As a way of explanation, the notice simply identified the legislative objective to restrict the participation in racing of members of the jockey's household. Minutes from contemporaneous meetings of the Racing and Wagering Board either failed to mention the rule change or simply acknowledge the board's approval of the change. As noted earlier, the change did not include siblings. Siblings have always been exempt from the rule. Other prominent horse racing states, including Kentucky, California, Florida, and Texas, do not mandate coupled entries for married jockeys or members of a jockey's household, and no scandals have arisen from their failure to do so. Notably, the model rules of racing promoted by the Association of Racing Commissioners International also contain no provision mandating coupled entries based on jockey relationships. In discussions earlier this past year with Executive Director Williams concerning the Commission's perceived need for the mandatory coupling rule for married jockeys, I learned that the Commission believed New York's evidentiary laws on the marital communications privilege likely presented a barrier to its investigators, preventing them from thoroughly examining potential allegations of match fixing or collusion between jockey spouses. As I set forth in detail in a memo to Director Williams on August 20th, 2021, my research indicates current New York law presents no such barrier. The current mandatory coupling rule for married jockeys and members of a jockey's household is unfair and unjust. It treats married jockeys and members of their household differently than other participants in racing, and it does so based solely on marital status. The rule presupposes match fixing proclivities in married persons and assesses a penalty in advance of guilt, even in advance of the couple actually taking prohibited actions. It reminds me of the Tom Cruise movie Minority Report. In that film, set in 2054, the police try to arrest Tom Cruise for murder, even though he hasn't committed one. Instead, they base their warrant on a suspicion that he will commit murder on a future date. The current mandatory coupling rule for married jockeys is also outdated and tone deaf. All of the couples I know want to beat one another when they're placed in direct competition. This rule targets elite athletes who happen to be married. If anyone is likely to be competitive with their spouse, it is certainly a fine-tuned athlete who has dedicated years of their life to honing skills to compete at their highest level. Modern girls and boys are no different in this respect. They each want to win, no matter who the opponent is. The competitor doesn't want to lose, even less so when pitted against their spouse. The current mandatory coupling rule for married jockeys is also inconsistent with other rules in New York racing. In fact, just this summer, a father and son competed against one another at the Saratoga Harness Track, and they did so as separate entries. The son won, and the betting public loved the human interest story. I can't imagine the father wanted to lose to the son, and I also can't imagine the son didn't want to beat the father. In fact, he was quoted in a newspaper article that says, there's no one I want to beat more than my dad, and that's just the business. You have to crave winning in order to succeed. The current mandatory coupling rule for married jockeys is also detrimental to New York's horse racing industry because it suppresses opportunity and competition for both members of the marriage. In doing so, the rule does more damage to the quality of New York horse racing than it does to protect its integrity. The risk posed to the integrity of horse racing and wagering by permitting married jockeys to freely compete against one another is incredibly minuscule and compared to the encroaching forces of corruption being monitored by Interpol's Sports Integrity Unit and others throughout the world. Finally, the current mandatory coupling rule for married jockeys is redundant. Racing stewards have vast power over the conduct of a race, and today's technology gives stewards tools they didn't have in 1985. At the investigatory stage, stewards and commission investigators may interview witnesses, search the grounds, and review video footage from the race. Removing the current mandate to couple entries from married jockeys will not curtail these investigatory powers, and as noted earlier, the commission steward may mandate coupling at any time if the steward finds it necessary in the public interest. Thank you for your attention to this matter, and I'm happy to answer questions.
Well, thank you very much for your viewpoint, Assemblywoman. Before we open up for questions, would it be possible for you to send me a copy of your prepared remarks?
Absolutely, we will do that momentarily.
I appreciate that. Staff, any questions for the Assemblywoman?
Sure, Rob, it's Ed. I'll jump in with a quick one. Assemblywoman, would you recommend that the commission not regulate in this area at all, or do you think disclosure or other steps would be appropriate? I'm just curious about your views on where you think the regulatory end game should be on this topic.
Thank you, Ed. I think that transparency is always a positive, and so I would absolutely recommend that there be disclosure. In fact, the bill that was vetoed included a disclosure requirement.
Thank you.
Do you have any idea how disclosure would work?
Well, I think it would work the same way that disclosure works in the other coupling regulations. You know, you noted in the program.
Okay. Anyone else have any questions for the Assemblywoman? We appreciate you taking the time to address and the thoroughness of your comments. And I look forward to adding those to the formal record.
Thank you very much. And I appreciate the Commission's interest in this topic.
Thank you. Our next participant is Scott Sadin from the U.S. Integrity. He is the Chief Operating Officer. U.S. Integrity is a technology-driven integrity and fraud monitoring and prevention company who has professional and collegiate sports leagues, as well as regulated sportsbook operators and regulators as clients. Mr. Sadin has served in operational management capacities with financial service institutions such as Apollo Global Management, Tourbillon Capital, and MSD Partners. While working in the financial services, he assisted with the developing of trading surveillance programs aimed at identifying potentially suspicious equity and debt transactions. Mr. Staden, is Mr. Holt also with you, or are you representing U.S. Integrity alone?
Thank you. Yeah, thank you very much, Rob. I appreciate it. I'm going to introduce my partner and the CEO and co-founder of U.S. Integrity, Matthew Holt. He'll give a quick background on himself and then a background on U.S. Integrity, and then I can comment on a couple of things at the tail end of his presentation. But I do want to thank the New York State Gaming Commission for the interest in this topic and for allowing us to speak today.
Thank you. Matt Holt is the founder and president of U.S. Integrity. I'll turn it over to you, Matt. Thank you.
Thank you. And again, thank you to the New York State Gaming Commission to allow us to speak today on this topic. We think it's a really relevant topic. And I think a brief history of U.S. Integrity sort of curtails into how important independence and conflict-free is. So I worked for a company called Cantor Gaming. We launched the first regulated mobile sports betting app in the country. And I was also the COO of their sister company, CG Analytics, which was a licensed information service provider in the state of Nevada. And in doing so, we worked with the NFL, NBA, NCAA, NFL, and basically everybody for game integrity and fraud prevention services, and understood the importance and the value, not just to those in those leagues, teams, universities, and conferences, but to the industry as a whole, to have the leagues and teams and universities participating and getting educated on sports betting and what it meant to them and what the associated risks were. So I started U.S. Integrity in 2018 because I understood that there needed to be a truly independent, conflict-free technology and data-driven sports betting, compliance, game integrity, and fraud prevention firm. And when we were 2 months old, we participated in an RFP with basically all the big companies that are now suddenly publicly traded that I'm sure you've heard of as at the New York State Gaming Commission to be the official integrity provider to the SEC. And we won because of the 13 companies in that RFP. We were the only one that was truly independent and conflict-free. We always tell people you wouldn't allow an arresting officer to be a judge in the same case. You can't allow your odds maker to be your integrity provider. We now work with the SEC, Pac-12, Big 12, NBA, Major League Baseball, just about every major professional and collegiate sports league. As some of you all may have seen, we also recently just released a deal today with Learfield where we work with have access to their 1,400 universities across the country because we think it's important that everyone is educated and up to speed with game integrity, fraud prevention, and what, regulated gambling means to them and the risks associated. But we always say that conflict-free is the most important thing. Independence is the most important thing. Sports betting, horse racing is often compared to the financial services world, even in terminology of its employees, risk managers, traders. But at the end of the day, imagine in the financial services world, rather than having to file trades with FINSA, or FINRA or SEC, you just said, oh, we'll let you know if something's wrong. The idea of, there needs to be independent monitoring, there needs to be independent reporting. And I think that that's kind of where we're getting to today, the idea of independence, conflict-free, and what it means to the ability to not just alert the public to potential conflicts, but to make sure that the folks independently monitoring it also don't have those conflicts. So I'll turn it over to Scott, who has, prepared some stuff to talk about with our company. But thank you all again very much for the time today. Thanks, Scott.
Yeah, thank you, Matt. And I just want to kind of reiterate the importance of independence and how we sort of commit, at least from USI's perspective, to being conflict-free. I recognize this is not necessarily a plea to the commission, but instead more of a sort of a representation of what we do in the industry and why we think independence is important. So as Matt mentioned, conflict-free to us means that our core business is 100% dedicated to integrity monitoring and fraud prevention. We don't create, distribute, or offer any odds for wagering. Our only risk management tools are related to identifying anomalies in the wagering market that may indicate potentially nefarious behavior. And the way we enforce that all starts with policy, right? So every employee, subcontractor of USI is required to review and agree certain policies that are very much USI specific. They require disclosure of any potential conflicts of interest and outline our expectations on confidentiality, ethics, professional conduct, obviously background checks are run, et cetera. And ultimately, this allows USI to sensitively handle investigations to all key stakeholders across the industry, whether it be sportsbook operators, regulators, or collegiate conferences, universities, professional sports teams, and leagues, for circumstances in which there may have been betting-related suspicious activity. So I think that really is what we wanted to cover today, just to kind of show some of the things that we take super seriously at US Integrity, and of course are available for any questions. But we wanted to make sure we kept it tight, and we do appreciate the New York State Gaming Commission for allowing us to speak today. Matt, I think you're still on mute.
Yeah, I remember the first speaker talked about inside information. I could tell you, as you know, a licensed integrity provider in 33 states, and we work with 99% of the regulated sports betting operators in the country. To his point, that misuse of inside information is the biggest issue we deal with. It is almost a weekly occurrence that we deal with people profiting off the misuse of inside information through sports betting. So I thought he brought up a great point on that first one, and it's one that we combat constantly. And I hope that through policy procedures and more monitoring down the road, we could sort of curtail some of that inside information misuse that currently takes place. And thank you again, everybody, for the time today.
We appreciate your participation. Anyone have any questions for US Integrity?
Yeah, Rob, it's Ed again.
Sure.
For the US Integrity folks, have you seen, to the extent you're able to discuss publicly in your investigations, issues in which people with familial relationships or who share the same household may or may not have given the effort that bettors expected, in placing a wager? Has that kind of issue come up in various sports globally in your experience?
Yes, to some extent, but I think what's more prominent right now is those familiar issues affecting inside information. Someone may not be able to participate because they have a pending suspension, COVID issues, sickness suddenly, even an injury that's lingering. That means that they won't be effectively be able to participate at 100%. And then those people utilize that information in the betting markets to take advantage of those situations. So it's not just a matter of the actual integrity of the events themselves and the participants in those events, but the betting markets being affected by the fact that there's inside information being placed due to that familial issue going on. And trying to figure out which is inappropriate is the most difficult thing, right? A college quarterback calls his brother and tells him, hey, don't bother coming to the game, bro, because I'm hurt and I won't be able to play. And then the brother takes that information and inappropriately uses it. It doesn't mean that the original athlete had any misintent, but somewhere down the stream, sometimes this information gets misappropriated.
But for more ongoing type of relationships, are there jurisdictions around the world in various sports? Are they concerned with that type of thing? For an example, spouses playing against each other in tennis doubles or that type of thing, or is that generally considered a buyer beware situation from the wagerer's perspective?
What we try to do for licensed operators in regulated jurisdictions where we work is just alert the betting public so that the regulators are aware, the operators are aware that there is this situation, because we always talk about the integrity of events. What normally happens is people get mad when they lose a bet and then find out there's a familial issue. Well, hey, I didn't know this was the case before I made the bet. Now I want my money back. So at least if the regulators are aware, the operators are aware, number one, they could combat it with lower wagering limits. They could lower the limits on those events so as they're not taking as high of stakes. And then number two, at least they can be prepared to deal with potential consumer complaints when they come because they were alerted to them ahead of time. So what we try to do is make sure everybody's alerted and aware of the situations, so that they can be prepared for potential backlash that could come from bettors who lost money in those situations and claim that they weren't aware of the familial issues.
So in those situations, is the action generally taken by the sports books as opposed to the regulators, or do regulators get involved as well?
I think a lot of times it starts with the sports books themselves making, we send out an alert, it goes out to all regulators and operators across the country, and now they have the ability themselves to act on that alert and say, A, either we want to take down the event because we know it could be problematic. B, we're going to lower wagering limits on the event because again, it could be problematic. Or C, at the very least, we're going to be aware of it so that if consumer complaints come in, we can at least have a prepared disclosure to them that yes, we were aware. Yes, we still thought it was fair. Yes, we still maintain the same wagering limits, and here's why it's okay. But I think that it's important that there is a disclosure and that they are made aware so that they have the opportunity to either suspend betting, discontinue betting, not offer wagering, or at least be prepared to deal with customers who may have a poor experience because they weren't aware when they placed a wager.
Thank you for your perspective.
Thank you very much.
Again, we appreciate your taking the time to participate today. Anyone, Tom, Mr. Annapolis?
When you put out the notice on integrity issues, what percentage would you say that the familiar issues represent related to your integrity alerts?
Very small. I would say less than 5%. The vast majority of our alerts right now are match fixing around the world, tennis obviously being the highest rated sport. We also have an obligation to, resend any alerts that other integrity providers from around the world may have located, may have discovered. So I would say match fixing is number one, misuse of potential inside information number two. And when it comes to the percentage of those alerts that have to do with familial issues, or conflicts of interest, let's just call them conflicts of interest in the events, I would say literally it's probably 1 to 3%. It's a very small percentage.
Thank you.
You're welcome.
Again, we appreciate you taking the time to assist us on this issue. Thanks very much.
Thank you all.
Thank you.
The next participants are Terry Meeks and Mindy Coleman. Terry Meeks presently serves as the national manager of the Jockeys Guild, and he's maintained a distinguished career in racing, having worked in some capacity since 1972. Among the positions he has held include special assistant to the commissioner of the National Thoroughbred Racing Association and vice president for the NTRA Racing and Industry memberships. He's also held positions of president and chief operating officer of the New York Racing Association, and has worked at such high-profile racetracks as Calder, Gulfstream, Keeneland, Oakland Park, Arlington Park, Hawthorne, Churchill Downs, Hialeah. Mindy Coleman has served as counsel to the Jockeys Guild for over a decade. Previous to the Guild, Ms. Coleman had a private law practice focusing on bankruptcy and construction litigation, and she has been very involved in the Permanently Disabled Jockeys Fund and the Brain Injury Alliance of Kentucky.
Thank you, Rob.
Terry, are you?
Rob, can you hear me?
We can hear it, Terry, and we heard.
Thank you, Rob. And I appreciate it, and appreciate the New York State Gaming Commission and asking for the Guild's input on this matter. At this time, I would like to refer to our Guild's counsel, Mindy Coleman, because she's been more involved in this, and with her comments, and if need be, I'll follow up.
Thank you. Ms. Coleman?
Good morning, Rob, the New York State Gaming Commission and staff, and all other participants on this panel. We appreciate you conducting today's staff hearing for the stated purpose to receive public input on the topic of regulations of potential conflicts in sports events upon which wagering occurs. While we're here today to speak with a broad topic with regards to those conflicts in sporting events, with all due respect, the Guild is specifically here to address the concerns regarding the mandatory coupling of entries in horse racings, as those are our participants and our membership. Our membership is regular participant in racing. As many of you are familiar, the Jockeys Guild is the organization that represents professional jockeys in American and thoroughbred quarter horse racing and has approximately 1,050 active, retired, and permanently disabled members. Since the inception, the Guild has served as a voice for jockeys when it concerns any sort of regulatory issues on a state level as well as a national level. For over a year, the Guild has expressed concerns regarding the New York Commission Rule 4025.10, which is a rule that was promulgated many years ago, requiring coupling of entries in certain circumstances that might present a conflict of interest among the competitors in the race. While we appreciate there is significant amount of history with regards to this rule and when it was promulgated, obviously that history has been previously addressed by two prior speakers. However, currently, this rule came to consideration with regards to spouses being coupled for betting purposes. Last winter, this rule when it came to Katie Davis and Trevor McCarthy. At the beginning of the winter meet in Aqueduct of 2020, Katie and Trevor had moved their tack from Maryland to New York. As had been widely reported in the media, Katie and Trevor married in December of 2020. Although they had been previously able to ride against one another while engaged and living in the same household, once they wed, strict enforcement of this rule was applied, requiring any horse ridden by two jockeys in the same race be coupled. Such actions resulted in financial harm to both jockeys in the form of reduced mounts and earnings. Both jockeys were essentially unable to fully and fairly engage in their careers as jockeys, as the regulation is enforced created a significant disadvantage to both jockeys when they were attempting to further their careers in business in New York. Prior to arriving in New York, both jockeys were coming off of two very strong and successful years where they had been competing regularly in Maryland. Mr. McCarthy was leading rider at Laurel Park, while Katie Davis was 7th in the standings prior to arriving at Aqueduct. To say that both jockeys were disappointed in this role that the rule played in their arrival upon New York was a severe understatement. There were reasons that they had come to New York. Racing is full of families who have made our sport their way of life, running the gamut of relationships from fathers and mothers, aunts and uncles, siblings, cousins, and so forth. Both jockeys come from racing families, with Katie Davis being the retired jockey, now trainer, of Robbie Davis. Two of Katie's siblings are also New York jockeys, Dylan Davis and Jackie Davis. And one of her brothers, Edmund, is currently training in New York. The reason they wanted to come to New York is because once they were wed, they wanted to be closer to their families. It should also be noted Trevor also has family relations in horse racing, as his father was a retired Mid-Atlantic jockey, Mike McCarthy. Now, when they came, they were not anticipating this rule to be in place or enforced against them. As alluded earlier, there's not a consistency in the uniformity of regulations throughout the United States. Although they had been able to ride against one another while engaged in other jurisdictions, once married, New York prohibited them from doing so. This rule not only affected both riders, but also NYTHA, the owners, the trainers, and the betting public, impacting the field size and the number of betting entries. In light of the importance of field sizes when trying to provide a top product, this rule, as applied, created issues limiting the field size and, as I said, reducing the number of betting entries, thereby potentially impacting the handle. While the Guild acknowledges and appreciates the policy behind the current rule, as indicated by previous speakers, this rule has seemed to become a bit outdated due to our current racing environment. This was originally done to mitigate the concerns that related parties may not expend their maximum efforts in the underlying race, with one party sacrificing the interests of a related party. However, we firmly believe that a more flexible rule should be in place to address these conflicts. As we've indicated, specifically, we believe the stewards, as the trained and qualified individuals overseeing racing, should be afforded the opportunity to use their discretion in allowing for spouses to compete against one another as jockeys, while still requiring that a jockey must ride a horse that is trained by his or her spouse. If stewards do allow spouses to compete against one another in a specific race, we also support any and all measures to ensure that the betting public is adequately informed with regards to such relationship. Additionally, the stewards would still have the ability to couple entries in the event it is deemed necessary, or if there's any concerns with inappropriate actions between the two parties that as related. The Guild believes this approach is a win-win for all parties. Married jockeys should have the ability to fully and fairly engage in their careers and still allowing for the wagering public to be protected. As indicated previously, in 2015, Regulation 4025.10 Section G was amended that notwithstanding the other limitations within the regulation, no entry should be coupled by reason of common ownership or training in any stakes in which the gross purse is over 50,000 or more, provided that the stewards may require any horses entered in a race to be coupled for betting purposes prior to the commencement of wagering, if the stewards deemed it to be necessary in the best interests of the public. To the best of our knowledge, since that rule was amended, there have not been any concerns reported or addressed with regards to that specific change to the regulation. While mutual coupling varies from state to state, many states have either changed or eliminated their entry coupling rules. It should be noted there have been and are currently jockeys who are married or cohabitating together in other jurisdictions who are permitted to compete against one another without the entries that they are writing being coupled. With regards to the ARCI model rules, which are the rules are silent on the mandatory coupling of married jockeys in a given race. However, they do state that a jockey shall not compete in any race against a horse which is trained by the jockey's spouse. And as previously mentioned, we had agreed with that as well. Additionally, we have provided information with the survey that was conducted by the ARCI model rules and have provided that to the commission. If at any time I can provide the additional results from that if so requested. Thank you again for your time, and we're happy to address any and all questions you may have.
I want to thank both of you for participating in today's hearing. I got one very quick question here. You had indicated that you thought you're fine with coupling if the stewards deem it necessary. Under what circumstances would you think that would be appropriate and be triggered?
If in the event that there had been any concerns, that the stewards had any concerns based on the two jockeys being permitted, whatever the familiar relationship being permitted to compete against each other, had there been a concern presented to the stewards, whether it be anonymously or otherwise, they have the authority to address those. And this is, as I said, that's actually reading the language from the rule as it was adopted with regards to the owners. We simply said that that would also apply, meaning that would also apply in the event that spousal jockeys were allowed to compete against one another.
No, I appreciate that.
Rob, this Terry, again, you got qualified stewards in New York. They know the history of the Davis family. They know the history of the McCarthy family. I would think it'd be, for them in this particular case, it'd be a no-brainer. Now, if the stewards, there's two jocks that came from New Mexico or Oklahoma or something, there's no familiarity with them. That'd be the steward's discretion. If there's some background, issues, whether it be through the TRPV or other state investigators, then, that's where the commission and the stewards are in charge of all licensees. And it should be no different between the jocks and or trainers. As Ben alluded to, the Frank Martins and the Jose Martins, and today the Engleharts, if there's some history of, collusion in the background, they should be coupled or whatever it may be. So same thing with uncoupling of entries in stake races. I don't think it's much of a difference here, whether it be, I think integrity is very important in protecting, the industry. but I think it's more transparency and uncoupling in stake races, and you get, NYRA's impacted as referred to, the handle. But at the same time, I think it's the integrity incumbent to, if you uncouple entries in stake races and one's used for a rabbit and the bettors are not aware of it, what it's being used for, then it should be the steward's discretion.
Well, thank you very much, Terry. Any of the staff here have any questions for the Guild? Mr. Burns, any?
No, I'd just like to add my thanks for their perspective and input.
No, we appreciate it.
Thank you. We greatly appreciate you guys taking the time and including us in this discussion.
Well, thanks again for your participation. Our next participants are from the New York Thoroughbred Horsemen's Association. It's Joe Applebaum and Will Alampevich. Joe Applebaum has been president of the New York Thoroughbred Horsemen's Association since 2013. He is a partner in Off the Hook Partners LLC, a breeding, racing, and sales company with a farm and training center in Ocala, Florida, and offices in New York City. Will Alampevich is the executive director of the New York Thoroughbred Horsemen's Association. Previous to this employment, Mr. Alampevich was the director of business development, director of guest services, and then the director of racing analytics at NYTHA. Prior to coming to New York, Will was with Portland Meadows for nearly a decade, serving as the director of wagering and guest services and general manager. He has a long history of racing, serving on both sides, including in the harness industry as well up in Canada. Gentlemen, appreciate your input.
Great. Rob, thanks for having us. Will's going to start and talk specifically about the rule, and then I'm going to give a perspective and answer one of the questions gaming posed more as a consumer advocate. So Will, why don't you take it away?
Great. Thank you, Rob. Thank you, Joe. Really appreciate it. We're here representing the 6,000 plus members who own and train horses racing at the NYTHA racing circuit. I've appreciated also listening to all the other testimony, especially recently from Mindy Coleman from the Jockeys Guild and Bennett Liebman. They covered a lot of the topics that we would like to cover. Unequivocally, integrity is paramount for our industry. There's a lot of emphasis there, and the importance of keeping our customers playing with confidence is important. When people wager on the races, that generates handle, and from that handle, there generates revenue for both the racetrack and us as horsemen. The predominant source of our purse account is the money generated from betting. So if our customers aren't betting with confidence, they're probably not betting, and we're directly impacted. That means our owners and trainers will run for less prize money, and then that'll decrease investment in the industry. Beyond the integrity, we have to put out a good product. And one of the key indicators of a good betting product for customer is field size. And when horses are coupled, that impacts field size. It reduces the amount of betting interest that a customer can bet on individually or in exotic wagers, horizontal wagers such as the exacta top 2, trifecta top 3, vertical wagers, and then horizontal wagers such as the pick 2, pick 3, pick 4, pick 5, pick 6. And at this stage in the game, after New York has expanded the rule, we're at a point now where we feel that it is the time to end all coupling in horse racing in New York. One of the reasons why we're able to come up with this conclusion is that people in New York are currently betting horse races in other jurisdictions that don't couple entries at all. And so if our customers are betting races from California, Illinois, and other jurisdictions, major jurisdictions, including Florida, where there aren't any coupled entries under any circumstances, Their expectation for New York can be the same. So we are going above and beyond and reducing the amount of betting interests to all of our detriment, that being the purse account, the racetrack, and any additional tax revenue. This is a little bit of a esoteric example, but one of the ways that New York protects the betting public, or tries to protect the betting public with with coupled entries, is that if there's a late scratch at the gate to one of the horses in the coupled entry, the other horse is also scratched for betting purposes and runs for purse money only. So now, suppose that there was a really good horse and a not so good horse in that coupled entry. Suppose the not so good horse scratches at the gate. The really good horse still runs for purse money only. It wins the race. The betting public might not seem to be directly impacted because they didn't lose any money, but of course they don't cash their winning tickets. The reason why I mention this is in the horizontal wagers, if your entry is scratched, you move to the post-time favorite. So if the post-time favorite doesn't finish second in that example, you now have a losing ticket, despite the fact that you correctly selected the betting interest. So you are directly impacted. So there's a lot of negative consequences to coupling entries. And we're at this stage now where major jurisdictions don't couple entries at all. And we believe New York should move towards that avenue as well. Looking at the questions that were provided in advance, what rules and model rules exist in horse racing and other sports to deal with potential conflicts? It's not directly a recommendation on our behalf, but the New York State Gaming Commission already has Rule 4035.2, foul riding penalized. And under subsection E2, it currently allows for stewards to potentially disqualify an uncoupled entry for the same trainer. So this is a good place to start if the New York State Gaming Commission was going to look at rules that provides for some type of penalty to ensure that the integrity of uncoupled entries continues in all races, should we be uncoupled for all entries. Bennett Liebman talked about the issues with disclosure of relationships. I agree with those comments, but I also believe that we should try our best and be as transparent as possible. Carrie Warner, Assemblywoman Werner brought up a good point. The host track that is conducting the race, Belmont, Aqueduct, Saratoga, or Finger Lakes, could absolutely put this information on their website, on their video displays, and in the program. Our customers utilize the host tracks program, TV display, and website for almost all of their information, and that is a great place to share the information. Bennett Liebman also did mention an issue with incomplete information. He brought up the Mike Smith and Chantel Sutherland example where they weren't exactly married, and that's just a great example. And people are betting on California races uncoupled, knowing full well that situation presented itself at the time when it did. And then there's one other question about the commission's rules for coupling be synchronized for thoroughbred, harness, and quarter horse racing. I'd strongly advocate for synchronizing all rules. Bennett Liebman talked about that as well. I just wanted to echo those sentiments, that to make it going back to the customer and making it easy and simple for them as possible. If we look after our customers, we're looking after our industry, and so that's in our best interest. Joe?
Thanks, Will. I appreciate it. In the notice that gaming sent out, one of the questions was, should the regulatory regime be uniform across all sports, or should wagering on certain sports be regulated differently than wagering on other sports? And if so, how? So the short answer to your question is it should largely be uniform, with select differences taking account of actual wagering systems and the differences between multi-participant events and bimodal events. not the actual sports themselves, not the action on the field, so to speak. The longer answer, though, is that gaming regulation in general needs to be thoroughly modernized, as the emergence of sports wagering has largely gone unregulated or left to self-interested leagues or gaming companies to enforce rules that are designed to protect their share price, their ownership interests, and not necessarily the integrity of the wagering contest, which I would suggest is more in line with what gaming's interests lie. For example, gaming's own notice has a question that begins, what are the proper penalties for a competitor failing to expend maximum effort? Well, in professional sports, basketball, football, etc., this basic integrity concept is violated all the time. It's actually a strategy called tanking. Most famously, in the last game of the last NFL season, not this year's season, the previous season, the Philadelphia Eagles inserted third-string quarterback Nate Sudfeld in the game's fourth quarter in a blatant attempt to lose and secure a higher draft pick. Well, this makes a lot of sense for the Eagles organization in a very Machiavellian way. And it may have even helped them make the playoffs this year. But it's inherently unfair to the wagering public. Well, in horse racing, there's actual rules that we have to govern this behavior. I'm not a lawyer, but I love to quote a good rule, 4035.4, instructions to jockeys. All horses are expected to give their best efforts in races in which they are run, and any instructions or advice to jockeys to ride or handle their mounts otherwise than for the purpose of winning are forbidden and will be subject all persons giving or following such instructions or advice to disciplinary action by the stewards and the commission. This is blatantly untrue of many professional sports. So what am I actually saying here? What I'm saying is that we have to decide, is integrity the most important thing that we're talking about, and enforce that across all sports instead of just in one sport. Horse racing, in many ways, has had a much higher regulatory structure, a much higher bar to cross. Even though that may not be the popular perception, that's the actual truth. We have to answer to all of you. Who did the NBA have to answer to about the Tim Donaghy scandal? I would say no one. So our recommendation, in addition to having no coupled entries at all, would be to have a thorough review of all the gaming regulations revolving wagering to make sure they're consistent across sports. Thank you.
Will and Joe, I appreciate your participating here. Does anyone have any questions for NYTHA? Ed, do you have any questions?
No, again, gentlemen, thank you for your input and participation. It's very useful to us.
Our pleasure.
I mean, Joe, you raised some really interesting points about the dichotomy between approach and treating and perhaps over treating the way that we look at things in horse racing. Do you think, as a general sense, the industry or the sports wagering in general should move towards horse racing, or horse racing move towards the way that there's been the hands-off approach and letting the market decide who's competing strongly or not?
It's my general impression, and I say this not only as an industry participant, but as a wagering participant, that the most fundamentally fair systems are systems where the house, so to speak, does not have an interest in one side or the other. And so a pari-mutuel system is inherently that. Now, people like to fight about what the proper tax rate on that should be, but other systems exist, what they call Pareto optimal systems, similar to exchange wagering, or a stock market or bond market structure that doesn't have the power of a league or the power of a bookmaker against the power of the consumer, which I think is important. My sense is on the sports themselves, there's some relief that can be given to horse racing. As you all know, you've heard me speak probably too much about the licensing disparities that could make it more competitive, and some more attention also given to the sports leagues in general and their actions in terms of shining a light on integrity issues and making sure that they are totally transparent with the public in terms of their investigations.
Again, I really appreciate the two of you participating today and taking the time to provide your input as we consider these issues.
It's always our pleasure, Rob.
Thank you.
Next up, we have representatives from the New York Racing Association. Is Joy, you say?
No, Joe is.
Not certain whether Joy's on, but I'll introduce her anyway. Joy Gardner is the Senior Vice President and General Counsel for the New York Racing Association. She had early in her career served as the Associate General Counsel at NYTHA. Prior to her return to NYTHA, Ms. Gardner served as a board member, Executive Vice President, General Counsel, and Corporate Secretary for Think 450, the National Basketball Players Association licensing and marketing subsidiary. Overall, she has nearly 20 years of experience in the sports and entertainment law. Jeff Canizzo is a Senior Director of Government Affairs at NYTHA. Previous to his present position, Jeff served as the Executive Director of the New York Thoroughbred Breeders for over a decade. Mr. Canizzo is a third-generation horseman from the Finger Lakes region of New York State, with his family being involved in the thoroughbred industry for the past 50 years. Joseph Longo is the Manager of Content Management Solutions at NYTHA, an accountant and finance professional. Prior to NYTHA, Mr. Longo was an auditor, financial analyst, and served as a Chief Financial Officer of Relito Park. Thank you for your participation here, and we look forward to hearing your comments. I know that Mr. Canizzo, you did circulate a slide to guide your discussion, and we all have copies of that.
Thank you, Rob, and thank you for having us at NYTHA on. We are going to talk through some of these pieces, much of which has been already stated by some of our partners here, but annual economic indicators for the racing industry highlight that field size has steadily declined over the years. In an effort to mitigate the downward trend, racing jurisdictions have pushed to eliminate the coupling of entries for the race cards. The coupling of entries has been around for some time and originally was put in place to protect the betting public, as we know. At a high level, horses in the same race that belong to one another or one owner or under one trainer are coupled together. Having the horses coupled allows the stewards to act against the entry in an event that they feel the betting public was harmed. It also serves as a deterrent to the entry, colluding against other betting interests. Several racing jurisdictions have since eliminated or uncoupled entries altogether. There are no longer coupled entries in California, Florida, Illinois, West Virginia, and Maryland. Outside of the United States, Ontario has eliminated coupled entries, as well as most major racing countries in Europe. The changes yielded an increase in field size and handle and resulted in subsequent increased betting interest. New York, as we know, is one state that must couple horses if certain criteria are met. As was stated, sections 4025.10, the limitation on entries, and New York State per mutual wagering breeding law specifically addresses when to couple entries. Criteria include common ownership, horses trained or ridden by a spouse, a parent, or a member of a jockey's household, and at the request of the commission steward if they find it to be necessary for the public interest. In 2010, as has been stated, New York amended the rules to allow a trainer to enter two horses as an uncoupled entry, as long as the horses don't have the same owner. As a result, the horses are considered separate betting interests. 5 years later, the State and Commission in 2015 amended the rules so that horses would not be coupled in stakes races with purses of $50,000 or more. The change positively impacted handle and field size in stakes races run since 2015 due to the stake schedule and purse structure in New York. I think it's very important to note, since both of those changes, racing and wager integrity has not been affected by either of those changes, nor has there been any evidence or concerns for the betting public. What I want to emphasize on now is what this would mean to fully uncouple entries in the state of New York. Specifically to NYTHA, in 2021, this would mean that there would have been 168 entries that actually were coupled. That would be 0.85 per day on overnight races. If you extrapolated that over an estimated 200 days of racing that NYTHA runs, removing the stakes races, the average handle per betting interest, which is about 150,000, holding everything equal, that would result in roughly $25 million in additional handle that would positively impact both NYTHA, its horsemen, and the state of New York. Some interesting other numbers wrapped around coupled entries. 61% of our coupled entries took place in claiming races, of which, as we know, would have the greatest impact and largest to New York State racing, where we need entries. On top of that, 50% of total coupled entries occurred at Aqueduct. So, as stated, and simply put, NYTHA believes and has believed for a long time now that it is time to fully uncouple entries to align us with the various other jurisdictions around the country itself, to be under one umbrella for our customer sets, as has been outlined by some of our other speakers here today. And we're here to address any questions you may have. So thank you.
Be taken to inform the betting public.
Go back and do it again.
Ron, can you start over?
Sure. If coupling was eliminated, what additional steps do you think should be taken to inform the betting public?
Well, I think it's the common answer that you've heard already today. We have various media sources, of course, at NYTHA, be it our website, our program, and other information that's distributed on track and virtually. I think that's the mechanisms as have been outlined that we would use to inform the public of any information that's pertinent to wagering that's going to occur on our races at NYTHA.
Thank you.
Anyone else have any questions for NYTHA relatives to this? Ed?
No, thanks.
Okay, we appreciate your input relative to the coupled entries position here, which, as you mentioned, is consistent with some other individuals that have spoken. And we appreciate the time you've taken to address this.
Thank you.
Thanks. Our next participant is William Gadamer. Mr. Gadamer is an attorney and business consultant with a long history of horse racing interest, as a fan, as a commentator, and as a horse owner. In his career, he has also held professional positions at McLean Industries, British Airways, Pan American World Airways, and Trailer Bridge. Of most importance to today's hearing, Mr. Gadamer has represented Katie Davis, a jockey who has alleged NYTHA's racing office had requested trainers not to use her to ride to avoid the necessity to couple entries and thereby reduce betting interest. Mr. Gadamer? Is he unmuted?
He's not muted.
Mr. Gadamer, hold on a second. We're having a little difficulty hearing you. You try again?
Is that better?
Yep, we got you. Perfect.
Okay, great. So I want to thank the commission and other panelists for the time this afternoon. I apologize if some of my presentation is repetitive from what some of the other participants have put forth. But as you know, my name is William Gadamer, and I'm an attorney for representing Katie Davis. And Katie Davis is a tremendously gifted athlete and the impetus for the legislation that was recently vetoed by Governor Hochul. Katie Davis is a licensed jockey in New York State and elsewhere, and is a member of the Davis family of jockeys and trainers that include her father, Robbie, her brother, Dylan, and her sister, Jackie, all of whom are gifted athletes and collectively have ridden in New York and elsewhere for more than 4 decades. Each of them has dedicated their lives to caring for and protecting thoroughbred athletes. Despite her and her family's pristine reputation in the industry, she has seen her professional career severely damaged by this commission and this rule because she exercised her constitutionally protected right to marry and begin a family. She ran afoul of this commission and this rule when she chose to marry a similarly gifted professional athlete with a pristine reputation, as the aforementioned Trevor McCarthy. This damage was inflicted on her career by the commission and this rule, not due to lack of talent, not due to a political stance, not due to a lack of work ethic, not due to a lack of acceptance by owners and trainers of a female in an overwhelmingly male-dominated profession, not due to personality, not due to ignoring or dishonoring racing rules, but due entirely to the commission's stated belief that a spouse may not put forth an honest effort against their spouse. We need to let that sink in for a moment. This commission has a regulation that has as its underpinning the assumption that spouses are untrustworthy, or at the very least, that jockeys who are married are inherently trustworthy. Let's be clear. My client's career was damaged by this regulation. Owners and trainers who wish to avail themselves of her tremendous talent were burdened by the negative consequence of using her services under this regulation. In a business as competitive as race riding, any negative consequence causes considerable damage. For the reasons already outlined repeatedly to the commission, this regulation hurts taxpayers, horsemen, racetrack operators without any discernible benefit. In fact, it is regularly and openly mocked by commentators on TVG, a television channel dedicated almost exclusively to horse racing. While the commission takes great umbrage at the suggestion that this discriminatory regulation is aimed at women, there is no question that it has a disproportionate impact on women, and most likely will have a disproportionate impact on same-sex married jockeys when that situation inevitably arises. As such, it is my belief that it likely violates both the United States and New York State's Constitution and is an example of government overreach. The commission seeks to justify the harm this regulation rains down on married riders and the racing industry by alleging this regulation protects the betting public against dishonest married riders. It is a little more than telling that the commission seeks to assure gamblers that it is protecting them by admitting it is impotent to otherwise effectively police dishonesty or wrongdoing. The professed concern for the betting public is strongly undercut by the commission's willingness to allow its in-state franchise holders to aggressively accept bets on races from jurisdictions which have no similar requirement. To be clear, it is perfectly acceptable to the commission to have New York residents wager on Katie Davis and her husband in the same race without protection of the disputed regulation, so long as the race is conducted outside New York State. Therefore, this rule only inhibits New York State competition while granting out-of-state races an advantage. The New York State legislature sought to correct this anomaly by taking swift, overwhelming action, only to see the governor, who herself is married, veto it and refer it back to the commission. As the commission now seeks input on this and nascent sports betting oversight, it's laughable to think that it will implement restrictions on the NBA, Curry, or Antetokounmpo brothers. Sports history, including horse racing, is replete with examples of relatives and those with familial and/or intimate relationships competing honestly and earnestly against one another in search of victory and excellence. This regulation is directly aimed at and enforced against spouses and, by extension, in an industry that is male-dominated, specifically at married women. To contend otherwise is simply intellectually dishonest. New York, which is laudably among the leaders in assuring gender equality, is woefully retrograde in its insistence on this regulation. The commission should accede to the legislature's clearly stated position on this matter and rescind the regulation. The commission and racing authorities can and should protect the wagering public through its considerable power without resorting to this blunt instrument, which is discriminatory, outdated, and particularly harmful to my client. And with that, I'll end my remarks. Thank you.
I appreciate you letting us know publicly your position relative to this. Obviously, we're in the midst of undertaking this particular hearing at the request of the governor. So that should give you some indication of how seriously we are taking this issue. Does anyone have any questions for Mr. Gadamer?
Rob, I do. So, Mr. Gadamer, do you think this is an area that the commission should not regulate at all, or are there other measures that you would advocate that would advance protection of the betting public?
I think the betting public is adequately protected by the inherent power that the stewards and the racing commission have to police wrongdoing. I've heard, and I originally suggested, and I've heard other people embrace my original suggestion that disclosure would be helpful. I don't really believe that the disclosure will be all that important. Disclosure is always good. So a notation on the bottom of the racing program or in the entries, I guess would be marginally helpful. But I think that the racing public is generally aware, or can be made generally aware, of their married status. Certainly this instance has had plenty of publicity and plenty of play. And I think the betting marketplace makes up for a whole multitude of variables. And I guess to some bettors, the fact that Kay Davis and Trevor McCarthy would be one of those to go into their selections.
Thank you.
Again, I appreciate you sharing your viewpoints relative to this particular issue. And obviously, you'll be paying close attention to what the commission does in the future.
Thank you.
It's my understanding that we've reached the end of our scheduled speakers. So I want to thank everyone for their time in preparing and participating in today's hearing. I also want to remind people that they still may provide written input by sending material to our information mailbox at info@gaming.ny.gov. That's info, I-N-F-O, @gaming.ny.gov. Procedurally, staff will gather the various information we received today and via written submissions, and ultimately make a recommendation to our commissioners regarding the existing regulation and whether its prohibitions need to be reconsidered. Again, I thank you all for participating, and this staff hearing is now concluded.